I confidently said that we were going to leave the information memorandum, but there are two passages which I didn't show you, which I do need to show you.
Yeah.
It's in Core Bundle 2, tab 23, and the two passages are first on page 377. Just above the risk factors, there's a section headed non-resident partners, which is dealing with a situation where a partner becomes non-resident for tax purposes, etc. And just above the bits in capitals at the bottom of that, there's a statement. Mr. Thornhill KC has advised that whilst he does not consider that such a deemed retirement of a non-resident partner would give rise to a clawback of tax relief previously claimed by such non-resident partner in respect of trading losses of the partnership and or interest on any borrowings by such non-resident partner to finance the acquisition of his or her interest in that partnership, the matter is not free from risk. And one sees that then being reflected below in relation to the risks, etc. And that is at the top of page 378. There is some risk that a non-resident tax partner who's deemed to retire from the partnership may suffer a clawback of tax relief, etc. And then just below that is the second passage, which again is blue. Current inland revenue practice will treat partners as associated for the purposes of establishing the small companies rate for corporation tax in respect of companies which they control. Before subscribing, partners who control their company should always consult their company's tax advisor to ascertain the impact of subscribing on the company's corporation tax position. What that is essentially saying is that because of the risk of association with small companies, what you could do here is muck up your company's tax position, and you need to take specific advice in relation to that. Now, what those two points illustrate really quite nicely is that you have got specific identified risks, and where those are identified, they have to be set out clearly. The idea that by saying that inland revenue can challenge a tax return or tax computations or anything else, which everyone knows, you're thereby saying that there is any doubt about the matter at all, is, we submit, unreasonable. Can I then take you to the next documents which we need to look at, which are in relation to the documents which were signed by the investors for SAD 2 and SAD 3. And for these purposes, we need, please, supplementary bundle 1 and tab 1. And these are described in the bundle as the application documents, and they're referred to by the judge in the judgment. And what you've got, if you just go to page 2, please, is effectively a bundle of documents. And just running down, you've got a subscription checklist, an application procedure, money laundering prevention practice, subscription agreement, and so forth. So this is effectively the pack which you have to sign in order to subscribe to the documents. And the subscription checklist starts on page 3, and you see going down all sorts of things in relation to the matters which are checked off as being satisfactory with ticks on them. And then if you go over the page to page 4, you'll see a form which has to be signed by the subscriber and countersigned by the financial advisor at the bottom. And what this provides is in 4 subparagraphs. The first is in 3 subparagraphs, and the second is a separate subparagraph. 1.1, Scots, the operator, the LLP, and their respective officers and staff, so for present purposes directly applicable to Scots. 1.1.1, have not provided and do not provide any investment, taxation, or other advice or recommendations for me generally, and specifically in connection with the Second Scots Atlantic Distribution LLP. 2, have not been and are not responsible for assessing the suitability of the Second Scots Atlantic for me, my needs, or any purposes or aims of mine. 3, are not and shall not be responsible or liable in any manner for any loss resulting from any such advice, recommendations, or assessment given by, or any negligence, fraud, or otherwise of the IFA or other suitable qualified person, as referred to in 1.2 below, or resulting from any failure on my part to obtain such advice, recommendations, or assessment. And 1.2, it was and is my responsibility to obtain appropriate advice, recommendations, and assessment as referred to above from an independent financial advisor or other suitably qualified person. Now, just running through those words, plainly, these words have to be read in accordance with the information memorandum and the express the acceptance of responsibility, which we looked at by Scots on the first page of the information memorandum. And in particular, the large section which says that they accept responsibility and have taken all reasonable skill and care, etc., etc. Secondly, when you then look at 1.1.1, they haven't provided and don't provide any investment, taxation, or other advice or recommendations for me generally, and specifically in connection with the Second Scots Atlantic Distributors LLP. That does not, in my submission, provide any disclaimer whatsoever for that for which they've expressly accepted responsibility on the front page, the first page of the
So that's for information contained in the IM.
No. Secondly, little 1.1.2 is on a fair reading, looking directly at the individual position of the investor. We're not responsible for seeing whether this is suitable for you, or for your needs or purposes or names. We're not looking to see whether or not you have enough tax relief, tax income available. We're not looking to see whether you're resident in the United Kingdom. We're not looking and seeing all the individual factors which make the general scheme applicable. Little 1.1.3, what it actually says is they're not responsible for loss caused by negligent, fraud, or otherwise of any independent financial advisor. So it's making absolutely plain they're not responsible for anyone else, or from any failure on my part to obtain such advice. So they're saying, essentially, if you're under a duty to make it, we're not responsible for failure to get it. It's not saying, if we've made a negligent misstatement in the information memorandum, we're not liable for it. And then 1.2, the question is, what is appropriate advice? What is appropriate has to be read in connection with what's in the IM. Who's it from? Any independent financial advisor or other suitably qualified person. Not a tax silk. Anyone who's able to ensure that the information memorandum is read properly. So in summary, that section doesn't, in our submission, help at all in relation to responsibility for the memorandum. Then you get the subscription agreement.
Sorry, by that you mean duty. You mean it doesn't help in relation to duty?
Sorry, my lady,
Sorry, you said doesn't help in responsibility for the IM. Maybe
sorry,
you
in,
made that
in responsibility for statements made in the IM is what I, that was meant to be shorthand for, my lady.
Right.
Then we get the subscription agreement. You've got the subscription agreement at page 7. Each of these have got to be signed, they've got to be witnessed at the bottom, and they've got over the back to be filled in as well by the IFA at page 8. And they identify the person who is going to be below. The subscriber is effectively the individual. For these purposes, each of my clients, each of the claimants in this litigation. That's paragraph 1. Paragraph 2 is instructing the operator to arrange for advance interest. And then paragraph 3 contains a series of warranties. First, over 18. Second, experienced in business matters and recognise the partnership as a specialist venture, has no history of operations or
Speculative.
Sorry?
Speculative.
Speculative, I'm sorry. I always need to go to the opticians.
Very small writing.
Third, no established market, etc. Then fourth, and importantly, he or she has read and understood the information memorandum dated on or about the 23rd of October, and in particular the section headed risk factors. So you've obviously got to read these warranties in the light of the fact that you've got the risk factors and, I would say, the statement on page 1 of the acceptance of responsibility by Scots. Next one is that he's contributing on his or her own account, in parentheses, not for someone else. Next one, resident for tax purposes in the United Kingdom, seen the relevance of that. And the next one is then this. He or she has only relied on the advice of, and then or, has only consulted with his or her own professional advisors with regard to the tax, legal, currency and other economic considerations relating to subscription to the partnership. Now, points of construction first. It's or, my submission, natural reading disjunctive or, only relied on the advice or has consulted, only consulted with his own professional advisors, etc. Not a disclaimer for responsibility in relation to the information memorandum. What in my submission this is plainly aimed at is the situation I adverted to this morning, where you don't get it being said, well, I phoned you up, you gave me some advice either about my own position or more generally. And note in that context, the or has only consulted with. It's either reliance or only consulted with. Plainly narrower than only relied on and consulted with. And just taking the point one step further, could not possibly mean that there is no reliance on a statement focusing for the moment at Scots, which is made in the information memorandum and which Scots make negligently. Then the next one, financial ability to bear the economic risk of subscription, etc. Then 4, effectively a mechanics about delivery. 5, hereby confirms that he or she has read and understood the terms of the information memorandum, so starts off again, this is the second warranty, that they've read the information memorandum, and has taken appropriate professional advice before submitting this application, and is aware of the risks attached to his or her becoming a member in the partnership. So we've again got appropriate. What is appropriate in my submission depends upon what it is that you are being told in the information memorandum. You can and should rely upon what is in the information memorandum, but you're still required to take appropriate advice. In parenthesis, appropriate advice might be in relation to, for example, whether you're resident or not in the United Kingdom, all sorts of other individual considerations. Once you understand, however, the background to this subscription, this information memorandum, and once you read the information memorandum carefully, in my submission, this simply does nothing to provide any kind of general exemption for Scots. Still less does it provide any kind of get out of jail card for Mr. Andrew Thornhill in relation to his advice, which he's given knowing that it's going to be summarised in the information memorandum, his opinion and so forth is going to be made available to investors, and where he is given the opportunity and takes the opportunity to confirm his happiness with the IM. Now, I had intended to go to tax now, but actually what I'm planning on doing is going to the sections of our skeleton which deal with duty of care in relation to that, so that you've got the points, and so that if you give me any really difficult questions, I'll have some time tomorrow to deal with them. The skeleton argument, you may have it separately, but it's in core bundle 2 at tab 24. And for these purposes, we have got within the skeleton argument to the point where we are dealing, starting on page 395, with the skeletons run through the documents I've told you to, I've taken you to, and I've effectively made the submissions in paragraph 23 to you orally now. And then in paragraph 24, we make the point that if the IM and supporting documents have been intended to convey that neither the sponsor nor Mr. Thornhill bore any responsibility for the accuracy of the statements to the availability of the tax benefits, this could only have been done by clear and express statements in the IM and Mr. Thornhill's opinions. Having reconsidered that, I think I would say fairly, by a clear and express statement in either the IM or the opinions, that no use at all could be made of them, that there was no responsibility, and by a clear identification that one of the key risks for investors was accordingly the absence of the tax benefit upon which the whole scheme depended as a result of its fundamental analysis being wrong.
What was there, is it said against you, if you could just remind me, that there was such a clear identification in the section under the tax consequences, or the, where one goes straight, is taken to the risk factors, and I think the fourth or fifth risk factor turns to the risk that the Inland Revenue will not accept the trading documents or the LLP account or the trading accounts. Is that not a clear identification that one of the key risks for investors was the absence of the tax benefits?
Well, lady, my submission is no. What that was telling you was that the Inland Revenue doesn't have to accept it's actually tax
Yeah,
calculation.
but in the context in which that risk was identified, the reference to the risk that the Inland Revenue wouldn't accept the partnership accounts mustn't it, a reference to the fact that the Inland Revenue wouldn't accept that this was trading. Well, we're not talking about nuts and bolts, as it were, numbers. You know, they won't accept that it was the profit or the loss rather was 102,000. It was actually 102,478. And that's not what it's talking about. It's talking about the fact that there is a risk that the revenue will say, we don't accept these accounts because this is not trading.
So, my lord, there are three points in relation to that. Can we just get the exact?
Yes, it's my fault. It's page 377 of Core Bundle 2.
Thank you.
That was the cross-reference for the risk factor, sorry.
Yeah.
Don't
worry. 377.
Page 377. So you very helpfully took us through the journey from the para 372, which takes one across to risk factors at 377, and then the third paragraph under tax risks.
Yes.
That second sentence, the availability of tax relief depends on the Inland Revenue's acceptance of the partnership accounts.
Yes. Now, first of all, this is in the context, first of all, of the first sentence immediately before that. This is my first point. The Inland Revenue does not give advance rulings on any of the tax issues referred to in this document. And we know that that refers back to the reader of this, to the bit earlier on, where it said, doesn't give advance rulings, putting my language on it, but don't worry, we've been to Mr. Thornhill.
Whilst there's no advance ruling, we have.
Exactly.
Yes.
Then next, the availability of tax relief depends on the Inland Revenue's acceptance of the partnership accounts. Well, just pausing there, yes, of course that is true, but that is the case in relation to every tax return which is ever submitted. I mean, not partnership accounts, but in relation to anything which is submitted to the Inland Revenue. You can put in your tax return, they can challenge it. You can put in a corporation tax return, they can challenge it. And then it goes on, and tax computations and compliance with detailed rules. Well, picking up my Lord Justice my Lord the Chancellor's point, tax computations are therefore something different from the partnership accounts, and could indeed, in this context,
They
be
could. That's why they're not the same as what the first bit of the sentence is referring to.
Yes, my lord, I'm not suggesting for a minute that this document doesn't say the Inland Revenue. The document plainly says two things. It says you haven't got advance clearance from this. That's the first sentence of this. It's also in relation to what's said. It's also saying, in my submission, nothing more than the obvious, which is that the Inland Revenue cannot accept this. But all of this is in the context of whether or not in those circumstances it is reasonable for us to rely on the opinion of Mr. Thornhill, if we see the opinion directly, or in the statements which are, we say, attributed to Mr. Thornhill. There are no such things which are guaranteed in life other than death and taxes. We know that there is a theoretical risk, but if Mr. Thornhill had given competent advice, you wouldn't get this buried away with us looking and saying, oh, well, is it enough that we know that there's a theoretical risk? No, because the elephant in the room is that not only is there no doubt, but if you look at the Inland Revenue's trading standards references, you will see that they emphasise the badges of trade and so forth. We say, for reasons I'll come on to a little bit later this afternoon or tomorrow, that actually the likelihood of this being trading, well, we say that it wouldn't properly be regarded as trading. But even if we're wrong about that, this isn't something to be discerned from the bottom. It's though any competent tax advisor would have been saying, look, there is absolutely no certainty whatsoever of you getting this. There's nothing to support it within the revenue practice. What you're trying to do is avoid tax, not defer it as you do in sales and leaseback schemes. We haven't got any kind of support for a scheme like this, as it were, being supported. In those circumstances, we have to look at the statute. We have to look at the cases. If you look at the statute and the cases, actually the likelihood is it isn't trading, or the alternative is that it's very likely. Now, the way my learned friend seeks to use this is to say that read together, these documents mean we can't rely on what Thornhill has so emphatically said. And at heart, we say that's just not the law. We're aware, of course, of the theoretical risk that our returns may not be accepted. What we're not aware of, but we should have been aware of, is to take the elephant out of this room and into another one, the elephant in the room.
There's one way of putting it. You say that investors were aware of the theoretical risk, but not of the real risk.
Absolutely.
That's the way you would put it.
Absolutely, my lady. Well, given that one of the criticisms that we make of Mr. Thornhill is that he was over-emphatic. The central criticism is being over-emphatic. There's risk in every part of human activity, of course. But what was being presented to us as a basis for us to invest was we've done everything we can. We've gone to Andrew Thornhill. We can't go to the revenue, but we've done everything else we possibly can. We've gone to Mr. Andrew Thornhill as the head of public court tax chambers, and he's given us his blessing. And unless there's anything more on that, could we go back to the skeleton argument, which is in the same bundle? And what I was doing in relation to that was, having gone through the documents, page 395.
Yeah.
What we say, paragraph 24, I think I may have half read it out once, so I won't read it out, but that if you were going to have a statement of non-reliance, it needed to be clear and emphatic, and that there was nothing like this. Now, the judge refers to Brown and Innovator, and Brown and Innovator was a case on, as the judge found, very different facts. You've got the rather lengthy report in bundle 4, page 28. But the critical point we would submit in this context in Brown and Innovator was that in Brown and Innovator, on the IM, as quoted at paragraph 890, there was an exclusion of reliance for the information provided in this information memorandum or its completeness. No representation or warranty, express or implied, is or will be made as to the accuracy or completeness of the information, including without limitation all projections or opinions contained in this information memorandum, and no liability is accepted by Innovator 1 plc for any such information or opinions. Now, there is just nothing approaching that. On the contrary, you have, as you've heard me say several times now, an express acceptance of responsibility. Now, it is against that backdrop, in my submission, that one has to approach the judge's judgment. And could I ask you, if possible, to keep our skeleton argument open, but to look at the judge's judgment and pick it up on page 92, paragraph 91. The court may have it separately, but it's in Core Bundle 1 at tab 10.
Whilst we dig that out, the reading list very helpfully identified some transcripts, which I've read, and I've now probably forgotten, it's my fault. But was Mr. Thornhill ever asked, or did he ever give evidence about why there was no disclaimer? No sort of clause of the innovator type.
Certainly
Express disclaimer.
Certainly he was inferentially.
Inferentially, but I don't remember anything direct.
No.
Can I? We haven't, I think, given you all of his.
No, I don't think you had. But
It may not be at all relevant.
Can I investigate that?
Yes, thank you.
And
Thank you very much.
And come back.
Thank you.
I wasn't there. I have read it. I think there is something which skirts around it, but I don't think it deals with it direct. So I think it's the answer. But can I come back to you in relation to that? I mean, just in relation to that, I think it's common ground, but if it's not, it's certainly our position that the question of the existence of a duty of care is to be assessed objectively by reference to what passed between the
Yes.
claimants and the defendants.
And that may be the reason why we haven't been provided any transcripts. And I'm sure that as a matter of principle, subject to what Mr. Adams says, that's right. So it may be a red herring, idle speculation on my part, but nevertheless, human nature.
yes. Sorry, you were going to take us to the judgment.
So I was taking to the judgment, and I was just really picking it up. Now, paragraph 91, my lord, page 92.
Yeah.
Now, what's happened here is that the judge has identified the factors pointing in favour of the existence of duty of care. And I'm not going to go through those, they're apparent from the judgment, but at 91 onwards, he explains why he finds that there wasn't a duty of care. And you see him saying that for the reasons he develops below, he's concluded that Mr. Thornhill didn't owe a duty to the claimants in respect of his advice in connection with the schemes. The first thing he does is he draws a distinction between two groups of claimants. Now, I'll come back to that if I meant, and those are those who saw the opinions and those who didn't. And he deals first with the first group. That's the one who saw the opinion or whose advisor saw it. And he says that the critical factor, 95, critical to this conclusion are the facts that the IM clearly advised potential investors to consult their own tax advisors on the tax aspects of the scheme, and that no investor could subscribe to the LLP without warranting that he or she had relied only on the advice of and consulted only with their professional advisors. Well, first of all, he didn't then consider what the implications of that were. He didn't look at it in the context of the express acceptance of responsibility. And he didn't work out what the implications of this finding were. He then says, paragraph 97, he rejects the contention that simply because there was no language of disclaimer in the opinions themselves, it was reasonable for investors to rely on Thornhill's advice without making independent inquiry. Now, independent inquiry is one of those nebulous phrases. What does it actually mean? We'll look at the authorities either later on this afternoon or very early tomorrow. But without independent inquiry actually comes from the speech of Lord Oliver in Caparo. Here, in my submission, to have any force, it means without going and obtaining the advice of a tax silver. Because that's what they were being given. The fact that, for example, an IFA is required, who may tell you, look, you do understand, don't you, that this isn't a regulated collective investment scheme, all the things that an IFA might say, doesn't do anything about the need to go and redo the advice being given by a leading tax silver. And then he says, 98, that the opinion must be seen in the context of all the information with which potential investors were supplied. Most importantly, the only way investors had access to the advice was via the IM. It was only because his opinion was referred to that any investor might ask for it. Well, I agree with that, but that then requires you to consider the concept of the law in relation to investment memoranda. The court's already said, well, was the judge's attention drawn specifically to sections 40 and 43 or the equivalent statutory provisions and so forth? It wasn't. But when you look and understand what the law is, and he was referred to Cabarro, you can see the context in which this is being put forward. It may be that Mr. Adams successfully persuaded him that my clients were neither widows nor orphans, that they were engaged in a high-octane tax avoidance and so forth. I don't actually accept all of that. But so what? He knew that this was going to be used to induce sales, and the law in my submission is plain in relation to that. Then he rejects, starting at paragraph 99, Miss Day's submission that it would reasonably only have been understood as referring to the personal tax positions.
So do you take any issue with the second half of paragraph 98?
Well, it's what's meant by independent inquiry, my lady. I don't quibble that he was entitled to know that they'd come through IFAs, but you can imagine Mr. Thornhill, what his reaction would have been if it had been suggested to him that Mr. Thornhill's advice was equivalent to an IFA, or for that matter, equivalent to a solicitor at Stevens and Bolton, who's the only legal advisor who looked at his opinion. Known friends already told you there were also 7 other accountants who looked at it.
And just
Can you
remind me
see
why
one
it
different
has to
point?
be equivalent.
Sorry?
Why does it have to be equivalent? A solicitor or an IFA is as capable, given, as you've said, this is all a question of fact, of looking at it and saying, I don't think these facts are good.
Well, it comes...
Or like, never mind that Mr. Thornhill's
Yeah.
such an eminent taxer. I think he's rather over-egged the pudding here.
Sorry, not.
There's a serious risk that this won't work.
But
That's what that second part of 98. I mean, it's making the point, isn't it, that because of the statements in the information memorandum and the warranties given, Mr. Thornhill it could not be said that he should reasonably have foreseen that they were just going to rely on his advice without taking independent advice of their own.
well, let's just break. You've got my introductory.
That's
comment.
what independent inquiry means. I don't think it means any more than independent advice from whoever.
Can I just park exactly where that is, because I would actually just like to show
I mean,
you.
it's very well. I mean, one of the problems with this case, and I appreciate this advice that's given by Mr. Thornhill is built up into this tremendous sort of, as it were, grand palace. But the truth is that it's not actually attached to the memorandum. It's not quoted in the memorandum. It's not actually even summarised in the memorandum, I don't think, as to exactly what he had advised. It doesn't say he advises is absolutely certain to work at all. And you know, if you wanted it, you had to ask for it. And not everybody asked for it.
Well, but, my lord, there are 2 or 3 points buried in that.
Well, they usually are, Mr. Stewart. That's the trouble with judges. You know.
I'll put them in a queue, my lord. Try and deal with
Touche.
them. Try and deal with them. Try and deal with them one by one. Is his advice summarised? Well, you've seen where he's referred to. You have got the express confirmation in the information memorandum that there is nothing inconsistent and they've taken advice from him, point 1. Point 2, you've got the centrality of the tax benefits. And point 3, you have got the entire absence of any indication of material risk. Now, those are all points I've made, but what I say in that context is that you don't need actually to see the opinion in order to get there. Point 2, and obviously, you have expressly permitted, so Mr. Thornhill has expressly permitted his opinions, plural, depending on which ones they are, to go to the investors. Just as the accountants in Candler allowed the accounts to go in the knowledge of the investment being made and so forth. Point 3, we are at the moment on the circumstances in which a duty of care will arise, and the critical point that we're on at the moment is the judge, having accepted there are all these factors leading to the imposition of a duty, is focusing on particular words either within the IM or, as we shall see shortly, to the subscription documents as rolling out that responsibility. They don't refer specifically to Mr. Thornhill, so there's no express exemption for him. But what the judge failed to consider is what the implications would have been for Scots if his construction was correct. And just to be plain on that, if Thornhill had said it's not plain what the position is, or there's a material risk, or I think that would have to have been reflected, just as one sees the doubt about the exiting partnership being reflected in the passage I showed you a few minutes ago. Can I, in that context, my lord, and I think this is the last of the taxes queuing up, promise you that I will come back briefly to independent inquiry, because I want to deal with that in the context of how that phrase is used, because for those purposes we need to look in a little bit at Lord Justice Neal and also at Naram, and I need to do both of those two. Yeah. We'd got to, I hope, the end of paragraph 98, and we're then dealing with the issue not being one of contractual construction, paragraph 101, and then 102, you find the judge accepting Mr. Adams' submission that we're dealing in an objective standard, what the reasonable recipient of the document would have understood it to mean. And the judge then rejecting the submission as the difference between the personal submission and the position of the tax advisors. And what the judge then does is to go through the various factors and say these are not limited in the way that it is sought to be limited. He rejects specifically the conclusion that this comes to 137. Rejects that it was reasonable for the claimants to rely upon Mr. Thornhill without independent inquiry, or that Mr. Thornhill should reasonably have done so, because the claimant's own advisors would lack sufficient information. And he finds at 141 that the fact that Thornhill's advice was given in unequivocal terms is irrelevant. Now, the first question that one needs to look at is 141. Suppose, to take Mr. My Lord the Chancellor's, as it were, postulation, and say, suppose that the information had specifically said, we have received advice from Mr. Thornhill, there is no doubt that the partnerships will be trading and that there is no problem in relation to the trading on a commercial basis test. In other words, there was an express identification. And suppose also that otherwise the language was the same. The judge's approach must mean saying that despite that, what is said would have been sufficient to get rid of reliance. Now consider the position of Scots. If the warranties and statements are to be made as, are to be put forward as they do, they must involve saying that Scots are not responsible for statements by them in the information memorandum. And once one says that, one immediately says, well, how on earth can that square with the statement on the front of the IM? The alternative is to read this, in my submission, fairly, and to say, we've got to take these documents together. We've got to take the information memorandum as a whole. We've got to take the subscription agreements together with the information memorandum, not least because there's a warranty that they've read and understood the information memorandum correctly. It is plain that we are entitled to rely on the information we're being given in the information memorandum. That is in accordance with what would happen if this were a statutory scheme. It is in accordance with the usual practice for the preparation of documents such as this. And it is in accordance with what, after all, the sellers are trying to do, which is induce people to buy these investments. In that context, the sellers are told, the buyers are told, we would submit, what Mr. Thornhill's advice is. They are, we would say, informed that it's in emphatic terms. The reason for that is that otherwise it would have to be specifically flagged up. And in those circumstances, the idea that where there would otherwise have been a duty, Mr. Thornhill can be rode out by what's said in the small print, is simply not consistent with the legal position. Now, I want to deal at the end, if I may, my submissions with what happens if I'm wrong about that in relation to UCTA, because for the Unfair Contract Terms Act, because there's a specific point in relation to that. But what we say, if you work this through at page 396, is that at paragraph 27, the only fair construction is that on a proper interpretation of the information memorandum, the sponsor expected responsibility that it believed the tax relief to be available, taken reasonable steps to check the position. Those reasonable steps included taking advice from Mr. Thornhill, because they said they had. And we would say that the consequence, they were also told that Mr. Thornhill had given unequivocal advice that the position was set out in the IM.
And you simply identify that by inference from areas where there is a qualification given.
Not simply, also from the passage I was discussing with your ladyship, one of my juniors said that I need to make another couple of points on that, but also in relation to that. What we say, that paragraph, the juxtaposition between you can't get advance revenue clearance, but don't worry, we've gone, is that we've got advice from Mr. Thornhill, which is equivalent. Equivalent's not there. The next best thing.
Well, I thought somebody might suggest it was equivalent, not just the next best thing. But the next best thing you say will do for your purposes.
Next best thing will do for my purposes. No, I can't say it's equivalent because plainly, if you get a confirmation from the revenue, then unless you've misrepresented the position to them or something of that nature which enables them to, they will be bound by it. And so I can't say it's equivalent. It's got to be the next best thing. Now, then one looks at the relationship between Thornhill and the sponsor. Now, it may not particularly matter, but you have seen that Scots were extremely careful to get Mr. Thornhill's sign-off to the statements which were being made in the information memorandum for reasons that can be well understood, because they were, after all, on my case, providing the plainest what representation that they've taken reasonable skill and care. And then you get, well, against that backdrop, do you have a duty of care between Mr. Thornhill and the investors? Now, in relation to this, we have gone through the cases which are identified. My learned friend, both below and in this court, places very considerable reliance on the NRAM decision. Now, NRAM is to be found in bundle 5 of the authorities bundle. I've lost. At tab 34. Now, we're going to this for three purposes. The first is to see just how far away the factual position in that case is from this case. The second is to look at what the actual test is for duty of care and to put the without independent inquiry matter into its context. And the third is to suggest that there is nothing in RAM which supports the idea that a duty of care should not be found to exist in this case. Now, the facts, as this court will know, are the slightly extraordinary one, which could not be explained by the solicitors, that the solicitors concerned managed to tell the unrepresented borrower that the loan was completely different from the actual position. No explanation was ever given. The critical document is to be found on page 1280 at letter E, where Miss Steele sent to Northern Rock the email which, as is said, is central to these proceedings. I need your letter of non-crystallisation of the sale of the above. I have a few letters on this one for previous other units being told. I also attach discharges for signing return, as well as the whole loan is being paid off for the estate, and I have a settlement figure of that. Can you please get these to be signed and returned as soon as possible? The whole loan simply was not being paid off. It was as simple as that. And how the solicitor came to send this document is one of world's great mysteries. And it is in that context that the Supreme Court considered whether or not the building society was able to impose a duty of care, notwithstanding that they, as the lender, had the most direct and clear information that what was being said here was not true. Now, it has, with respect, very little indeed to do with the sort of prospectus cases which go back to the 19th century, to a situation where investors are being asked, being sought to be induced. And one of the matters which, with respect, the learned judge in my submission got wrong was to focus on the fact that legal advisors ordinarily act on opposite sides of transactions. Of course, it's true they do. Solicitors so act, so do barristers. But so what in relation to what Mr. Thornhill was doing here? Mr. Thornhill here was not doing something which ordinarily barristers or solicitors are expected to do. He was advising for the purpose initially of setting up a tax scheme. Then he was providing advice which he knew would form the basis of an information memorandum. He was approving the terms of an information memorandum, and he was allowing his advice, if, as the Chancellor has pointed out, they asked for it, to be given to investors. It is actually distracting to think of Mr. Thornhill in this context as being a barrister. It may be slightly unfair to think of him as a second-hand car salesman along the lines of, she's a good little bus, I'd bet my life on her. It may be fairer to say that he should be viewed in the same way as one would view, for example, a valuer who gives advice about an investment enterprise unit trust scheme, who says and allows his name to be given to a valuation at £50 a square foot, which is central to the scheme being proposed, and equivalent, in other words, to one of the cases which you've got in the bundle, Ball and Banner.
Well, I think it's a bit unfair with respect to equate Mr. Thornhill with Mr. Hopkinson, the second-hand car dealer in Henry's and Hopkinson.
Yes.
Well, the following...
Not least because the whole point about that case, and I reminded myself because I couldn't remember whether it was a case about the Triumph Herald that was made out of two cars, but it wasn't. It was a case where I think the ball joint of the steering went and there was a terrible accident. But the reason why he was negligent was because he hadn't bothered to check the car over. He just said, oh, this is, even though the car was the best part of 20 years old, it was a good little bus, etc. That's not in any sense what is said to be the negligence here. It's not said, for example, that Mr. Thornhill didn't have the right qualifications, or that he wasn't experienced in the area, or that he hadn't researched the point properly. The essence of the criticism is that his advice was too bullish.
Well, Lord, can I just one...
If he'd qualified his advice, I mean, your whole case is if he'd only qualified his advice as he should have done, then we wouldn't be here today.
Dealing with the two buses, first bus, the analogy is this: with respect, that case did turn on the statement, "She's a good little bus. I'd stake my life on her." Without that, in the absence, given that he was acting for the garage and the seller was the hire purchase company, not the garage, in the absence of statutory intervention, there would have been no action directly against the garage. In other words, the negligence with respect didn't consist of not having invested. It was making the statement, "She's a good little bus, I'd bet my life on her," when he hadn't done anything to justify that. In other words, he was negligent in relation to that. So the negligence, in my submission, is properly to be categorised as the making of the statement in the absence of any proper basis to back it up. Here, the negligence is saying, there is no doubt that it's trading, when any competent barrister professional would have, in my submission, not made that statement. Now, plainly, one is looking at a situation in relation to Andrews and Hopkinson, where there was, very sadly, an accident, although in my submission, given the judge's findings, that would have made no difference. But that's the analogy. But second point in relation to this, in any event, I do not accept that the reasons why Mr. Thornhill were negligent change the analysis. If we're right, and I need to persuade you, of course, of this, that no properly instructed tax silk could have given the advice he did, and that the advice was not just over bullish, but as close to being a warranty that something that was not a warranty could be, then in my submission that is made out. And coming back to the point I was making, if you had got a scheme which depended on, for example, a combination of tax advantages and valuations from a valuer, and the valuer allows his advice to be given to investors and so forth, in my submission, that is the proper context in which this ought to be looked at. There is no special law for barristers in this field.
And I'm just, in the context of your submissions about NRAM, I'd like you to tell me, if you can, just how it was run below. We see that for your clients, understandably great reliance on Headley Burn. The judge says, yes, so far so good, but it's a long time ago, matters have moved on. More recent case is NRAM. And we can see, I think, although he has to deal with a lot of points, he does ultimately, I think, adopt the NRAM test fair and square and reach the conclusion that he does. Was the submission below, what is the submission now? Do you say NRAM is relevant, or a test of NRAM is not relevant to the sort of banner and ball situation, the very different facts that arise here?
So we say that the correct analysis well, let me answer the question directly. The correct analysis is, we say, set out in Lord Wilson at paragraph 19.
Right. Yes.
And can I just take you straight to that?
So paragraph 19, which the judge referred to,
He does.
paragraph 71 of his judgment.
One of the things which is important about paragraph 19 is that you don't get this independent inquiry. We'll see how that comes in. If you look at paragraph 19 on page 1282, what is noteworthy for present purposes, the emphasis given in the decision Headley Burn, the need for the representee reasonably to have relied on the representation, and for the representor reasonably to have foreseen that he would do so, expressly stressed in the speech of Lord Hodgson. In fact, it lies at the heart of the whole decision. In the light of the disclaimer, how could it have been reasonable for the appellant to rely on the representation? It's not reasonable for a representee to have relied on a representation, for the representation to have foreseen that he would do so, if it's difficult to imagine that the latter will have assumed responsibility for it. It's not reasonable for a representee to have relied on a representation. It may often follow it's not reasonable for the representation to have foreseen that he would do so, but the two inquiries are different. So what you've got there are the two objective linked questions. One, is it reasonable for the appellant to rely? Two, is it reasonable for the representee to have foreseen reliance? Now, just focusing here, nothing here in this paragraph about independent inquiry. We'll see how that comes in. And just also focusing there, what you are therefore saying is not, are there any other advisors around, or are these all investing through IFAs or so forth, or do they all know that the Inland Revenue can challenge any taxpayer's tax return or any computation or any partnership accounts or anything of that nature? You've got a fundamentally more basic statement. Where you then pick up the issue of independent reliance is when you get to the next page at 1283, and in particular paragraph 23, and they've been through Miss Justice Brennan in the Sutherlandshire Council. More important for present purposes is the reassertion in the Caparo Industries case of the need for a representee to establish that it was reasonable for him to have relied on the representation and that the representor should reasonably have foreseen that he would do so. Now, just pausing there, you already have my point about Caparo. So Caparo, you've got Lord Bridge giving the first speech, saying effectively, Lord Denning did a wonderful job in Candler and Crane. Parliament's given the answer in sections 40 to 43. And then he goes to Lord Bridge's speech, different part. Lord Bridge observes that a salient feature of liability was that the representative knew that it was very likely that the representee would rely on the representation. Well, just pausing there, let's just look at this in this case, looked at objectively. You're a tax silk. You say that there is no doubt that something is trading. You say that, similar in relation to the additional commercial basis test, you approve the terms of the memorandum. You allow your advice to go out. You know that it's being intended to persuade people to buy. Objectively, that's all you need for reliance. Then some months later in James McNaughton, the Court of Appeal, confronted with a similar claim against company accountants, rejected it by reference to the decision in Caparo. But Lord Justice Neal expanded on the need for foreseeability of reliance. I missed a crucial part. Lord Oliver observed that a usual condition of liability was that the representative knew that the representee would act on it without independent inquiry. So that's where we get the without independent inquiry. But to make any sense, that's got to be without inquiring of the same nature and the same sort. And if you put yourself objectively into the position...
Sorry, that's an important statement, and is there any authority for that?
What?
That it's got to be, that independent inquiry has got to be of the same nature and the same sort.
Well, I'm explaining
By
why...
which I think you mean a sort of a silk's advice.
Well, I'm explaining why that must be the case, my lady, if I may, because you're right, it is important. But it's this phase without independent inquiry. What does this actually mean in those circumstances? Well, I've already submitted that the key passage is 19. Need for the reasonably to have relied and the reasonably foreseen to have done so.
So what is your position that independent inquiry is actually an illegitimate gloss, that actually all you need is reliance and with or without independent inquiry, if you see what I mean?
No, I'm exploring, my lady, at the moment, what this can actually mean in the context of what's being put forward. Because the test, I would submit, is that you're looking at 19. We're about to look at Lord Justice Neal, who uses rather different words in McNaughton.
I think we've got to be quite careful here about this independent inquiry.
That's
I
what
just
I'm
had a
saying.
look at what Lord Oliver said. What Lord Oliver was doing was summarising what had been said in the speeches in Headley Burn. And the whole point about the independent inquiry is that is item or point 3 derived from he says what can be deduced from the Headley Burn cases, therefore, and he sets it out. It is, and 3 is it is known either actually or inferentially that the advice so communicated is likely to be acted upon by the advisee for that purpose without independent inquiry. So that's the context. And I rather doubt whether that context, if we go back to Headley Burn, will mean that the independent inquiry or the independent advice that you obtain has to be from the same source and of the same nature.
Well, my lord, I was absolutely with you until the last sentence, but
I'm sure you will. I'm sure you will.
but my lord, I'm going to cut out the bit of the curate's egg that I don't
Yeah.
like, and say I am with you until the last sentence. But can I just try and tell you where I'm going, and then seek to make the points as to why where I'm going in relation to that. This is this. First, the test isn't some nebulous one about independent inquiry. Independent inquiry isn't actually some defined term, and it will vary from case to case. So, for example, just to make that point good, in this case, in the Ram case itself, all you had to do was to look at your file, and you see that the loan isn't going to get paid off, and you're the lender. The test is what it's at 19, whether it's reasonable reliance. So that's the first point. Secondly, what is reasonable depends upon the statement. And if you need authority from that, you can go straight to Headley-Burn itself. The statement in Headley-Burn would have been actionable were it not for the fact that it was given without liability.
Yeah.
And so you can't divorce what the statement is with the reasonableness as to whether or not you're going to rely on it. Those are two sides of the same coin. Thirdly, and directly contrary to what the judge said, it therefore does matter what that statement is in terms of certainty. If you are told, we've been to pump court tax chambers, head of pump court tax chambers, and you accept what I've said, that this is the nearest thing to an inland revenue clearance, what you have to say is that it is no duty of care, because anyone in those circumstances would go and get alternative advice. That has to be the proposition. Now, as to the question of who it's from, and my Lady Justice Carr's who it's from, well, why would you seek to go off and get an independent financial advisor's advice, for example, or an accountant's advice, when you know that with respect to the tax bar, the reason that they make sometimes a not wholly immoderate living is because they're regarded as the specialists. That's how they're selling themselves. So that's the context in which this is being looked at. That's where I'm going with this. Can I then just show you the passages which support where it is? I got to Lord Wilson quoting Lord Justice Neal and the critical paragraphs at the top of 1284. Starts off with saying, consider whether and to what extent the advisor was entitled to rely on the statement, necessary to consider whether he did in fact rely, whether he did use or should have used his own judgment, and whether he did seek or should have sought independent advice. In business transactions conducted at arm's length, it may sometimes be difficult for an advisee to prove that he was entitled to act on a statement without taking any independent advice, or to prove that the advisor knew actually or in relation that he would act without taking such advice. And then, if one then looks at paragraph 25, he picks up the fact that there is the other consequence to a solicitor, that effectively it's operating in another context. And he then goes through the solicitor's cases and explains that it is presumptively unreasonable. And then his key conclusion on this is at paragraph 38 on 1288. And it's just below letter G. We should accept that a commercial lender about to implement an agreement with a borrower referable to its security does not act reasonably if it proceeds upon no more than a description of its terms put forward by or on behalf of the borrower. the lender knows the terms of the agreement and in this case is likely to have evolved and approved them. So in other words, what is being rolled up there is nothing easier than for a lender to know the terms of his own loan. And just to make that plain, over the page at 1289, between A and B, the explanation is no doubt in such circumstances not reasonable for the representation to rely on the without checking its accuracy. And that is, by contrast, reasonable for the representative not to foresee that he would do so. So that's where you get checking its accuracy. Now, how do you check the accuracy of a tax silk's opinion? You could check the opinion of a solicitor by going to a tax silk. You could check the opinion of an accountant, possibly by going to a tax silk or a solicitor. But is Mr. Thornhill really going to say it's unreasonable when I have said there is no doubt about something and I've been prepared to put this forward on the basis that it's going to be used to sell investments, that it's unreasonable for anyone to rely on what I've said without going and speaking to an IFA or a solicitor or another accountant?
Not a convenient moment to have a break.
It is. Can I just ask, 4:15 this afternoon or?
Yeah, 4:15. Yeah. So we break for 5 minutes.
All right. All right.
My lords, if you could look at core bundle 2 at page 397, which is in our skeleton.
Core bundle 2.
Tab, it's my skeleton argument, tab 24.
Right,
Page 397. Now, we, and to a considerable extent the judge, we submitted and the judge accepted to a considerable extent a large number of factors pointing in favour of the duty of care. We've identified particular features. One of them is the absence of disclaimer. And that's referred to in the passage which we've cited by Lord Bridge, absence of disclaimer or responsibility. And then at the bottom of 397, we point out the absence of a disclaimer, despite Mr. Thornhill being given the opportunity to make one. Now, my lord, in answer to Lady Justice Carr's question a few minutes earlier, my understanding is we'll get the passages, they're not in the bundles before you, but Mr. Thornhill was shown a disclaimer from another case and effectively said, well, you could have put that in, couldn't you? And he said, yes, I don't know why I didn't, or words to that effect. We'll find, I hope that's an accurate summary, but we'll find the relevant passages too.
Yes. I mean, we'll get the transcript up and we'll see. I don't think that's a fair characterisation of the evidence from memory. The evidence is distilled really in paragraph 98 of the judgment, which is Mr. Thornhill saying that he knew that the terms on which his advice would be provided were the terms through the IM.
Sorry,
Paragraph 98 of the judgment.
98.
I'll develop this in my turn. I had to rise because I really don't think that is a fair characterisation of anything that happened at the trial. He certainly did not say, oh, I wish I'd put in a disclaimer. He said, look, I knew the terms on which my advice were being provided. It was through the IM. The judge has accepted that evidence here.
Yeah.
And those were the terms.
Guilty for perhaps having
And that'll do.
He approved the terms of the memorandum, and if the judge is right about what all that means, then he didn't need a disclaimer.
Yeah,
That's really your
Yeah,
point.
I'll go through it in detail tomorrow because it's slightly stronger than that. But your lordship has the point.
Right.
I mean, 3 points in relation to that. First, my learned friend's right that you're going to have to look at what the IM actually says. Secondly, to suggest that this was a clear disclaimer for the reasons I've put forward is a pretty bold submission, even by my learned friend. I mean, these were small print and don't take any account of the express acceptances of responsibility. Thirdly, in relation to the question of Mr. Thornhill's own position, obviously, what he himself said at any time on this point is actually irrelevant, as I think is common ground. What he thought, he might have thought about why he did something 18 years on, in circumstances where he's being sued, is unlikely to be the sort of evidence.
I don't think that's the point that's being made with respect. I think the point that's being made is my understanding what the judge said, is that yes, it's always relevant to consider whether there was a disclaimer and what the effect of that would have been. We all know that because of Headley Burn. But what the judge is really saying is that what happened here was equivalent, if you like, to a disclaimer.
Yes, well, my lord, I've really addressed your
And you've
lordship.
addressed that.
Yeah, and your lordship has my points in relation to that.
We know from BCCI though that the opportunity to give a disclaimer is relevant.
Yes,
whether
and
or not the duty of
absolutely.
care. So it's really only in that context there might be any
Yeah.
value in this exercise of finding out what Mr. Thornhill
Well,
thought.
my lady, tempting as it is to go into Mr. Thornhill's mind, what we know is that he approved the terms of the memorandum, gave his advices and so forth, without himself issuing a disclaimer. We know what the terms of the information memoranda were. I've addressed you in relation to that. We know that he had the opportunity to put in a disclaimer, and subject to my learned friend's points about the equivalent effect of what was in the IM or the subscription agreement, we know that he didn't. Actually, at that point, why he didn't is actually, in my submission, irrelevant.
Okay, right.
But your ladyship is in advance of where I was. You picked up bottom of 397 the existence of an opportunity to put in a disclaimer, and this isn't merely a forensic point. All of this is in the context of whether it is reasonable to impose a duty of care on the defendant. Mr. Thornhill is not a babe in arms. He's being paid for his services. He's not giving advice at a cocktail party. And he knows the purpose for which his advice is going to be used. Just as my own friend will no doubt say, my clients are sophisticated and so forth, and they can reasonably be expected that if a barrister is going to allow his advice to go into general circulation and approve the terms of the IM, and he doesn't want to take legal responsibility for it, then he will say, no one can place any responsibility on my advice. And if he doesn't, that itself is a factor in favour of the existence of a duty of care. And the judge, this is our paragraph 31, other than the passages which my lord has referred to and Mr. Adam just referred to just now simply records without comment our submission, as you see from paragraph 31. Now, we then say, paragraphs 32 and 33, that the judge was wrong about the IM. I've been through those reasons. I don't want to go through them again. What I do want to do, I'm afraid, is reserve for tomorrow, because it slightly depends how much time I've got left, the arguments which are in paragraph 34 about the Unfair Contract Terms Act. That's not because they're not important, but they do involve looking at matters slightly differently, and I need to come back to those. So those, what I've now done, so that you can know that I'm not too far behind my schedule, is I have made the submissions subject to any thoughts that I have overnight in relation to duty of care, other than in relation to the Unfair Contracts Terms Act. And what I'm now going to do is pass to our substantive submissions as to why we say Mr. Thornhill's advice, contrary to what the judge said, was wrong.
Great. Thank you.
Now, for those of us who like to start at the beginning, and that is certainly myself when it comes to taxing statutes, could I just ask you to look at the key provisions which are involved in this, and we need for those purposes to go to Bundle 5, tab 44, where you have the relevant provisions, most relevant provisions under the taxing statutes. Now, these statutes in the current age have been around in substantially similar form since the introduction of income tax. These are not new or novel provisions, and they do not contain anything which those who deal with these matters on a regular basis would not be expected to be familiar with. And just to make some other basic propositions, trading, section 381, where an individual carrying on a trade sustains a loss. Trading is in general terms, carrying on a trade is in general terms a subset of carrying on a business. In other words, you can carry on a business but not carry on a trade. And you do not have anything approaching a statutory definition of trade. You have it used in various different contexts. You have it applied for a considerable period of time over a considerable number of years. And you have various statutory provisions which touch on the question. And this is giving relief for losses in the early years of trade, where an individual carrying on a trade sustains a loss in the trade in the year of assessment or any of the next 3 years, he can give notice, etc. And little 4, relief shall not be given under subsection 1 in respect of a loss sustained in any period unless the trade was carried on throughout that period on a commercial basis. So it's got to be trading and it's got to be a commercial basis, and in such a way that profits in the trade, or where the carrying on of the trade forms part of a larger undertaking, in the undertaking as a whole, could reasonably be expected to be realised in that period on and with a reasonable period thereafter. So that's where you get the triple requirement for losses within section 381 to come from. And then slightly differently, although not, I think, materially, you have section 384 at page 1394, which is restrictions on the right of set-off. Subject to subsection 2, a loss shall not be available for relief under section 380 unless for the year of assessment which the loss is claimed to have been sustained, the trade was being carried on a commercial basis, and then these are the slightly different words, and with a view to the realisation of profits in the trade, or where the carrying on of the trade formed part of larger undertaking and the undertaking as a whole. Now, you will understand for the purposes of this appeal, the third part of the test, a view to the realisation of the profits in section 384, or in such a way that profits in the trade that could reasonably be expected to be realised are not in issue. But the point for present purposes is that the statute itself shows trading and on a commercial basis as being part of the test. My now forgotten who asked me. Someone asked me whether it was made plain. My Lady Justice Simler asked me whether it was made plain to the judge that both trading and commercial basis were in issue. It was. It's in the written closing at which we've got in front of us at supplementary tabs 26, page 374, and actually rather more clearly in the oral submissions in day 10 at page 141. I'm not sure if we've got those oral submissions ready, but we can perhaps provide them.
What's the tab of the supplementary?
26.
Tab 26.
And we've got
Yes.
all of the transcripts below on Opus,
We've got all of the
so
transcripts
we
below.
can look them up.
Look at them with heart's content.
I mean, just if I can just read out this.
Sorry, paragraph.
And it's that they are separate considerations,
Yeah.
not to be looked
Yes,
at.
can I
together.
just read out? So it's supplementary tab 26,
Yeah.
which I've now
Page
lost.
374.
Starts at 256.
Yes, and it's at page 374.
Hang on.
Let me just.
Something right.
Oh, mine go up.
Which are you supposed to be looking at?
Sorry, I've got it's
Defendant's written closing submissions.
sorry, I think I've given a Duff reference. Let me just find the.
Oh, I know why.
Yes, I had given a Duff reference. The reference, I'm sorry, is at supplementary bundle 2, tab 26, page 334, paragraph 206. And this is buried in the interstices of the written submissions. And it's under the heading Application of the Law on Commercial Basis to the 5 Fee Factual Conclusions. The dictum from Wannell and Rothwell, which is the one which we rely on, referred to above, summarised as follows: uncommerciality is the antithesis of commerciality in a trade be conducted in an uncommercial way, either because its terms are uncommercial or is uncommercial in other aspects. And Mr. Justice Zacaroli, if I could just read the passage, I'll provide it, but it's at page 141 of day 10. Mr. Justice Zacaroli, do you run both tests? Ms. Day, we do absolutely run both tests, we do. Just to be clear, my lord, there's obviously the question of trading, but there's obviously the other two tests as well, the commercial purpose test and the view to a profit test, because you have to meet all three. So the point is plainly made that all three are an issue.
Well, that's the point about the dilettante art dealer, isn't it? Which comes from Mr. Justice Walker's judgment in
it does.
Wannell and Rothwell,
Yes.
which is quoted at 204.
Yes. The important point for present purposes is that the judge wrapped. There is a commercial element to the trading test, but simply because you fulfil the trading test does not mean that there is not a separate test of trading on a commercial basis. To those of us who did not grow up in this, it is easy to get the two confused. But the existence of a separate test in the Mr. Justice Robert Walker dilettante example is a good example of the difference between the two. And as you have seen from Mr. Thornhill's instructions, Scots were alive to the difference between the two and asked him to consider the two. Now, the fundamental problems with the judge's judgment in relation to his conclusions in the law start off with the central conclusion, which is to be found at paragraph, or starts at paragraph 177 of the judge's judgment. And he summarises the conclusions of the judge, and what he says at paragraph 177 is that the essence of the approach adopted was to start with the uncontroversial proposition the activity carried on by Warner Brothers, of which part was passed over to the LLP, was a trading activity. He then considered well, the fact that the LLP was carrying only part of the trade meant that the LLP was not itself trading. He concluded because there were others in the filmwork who carried on the part which was passed to the LLP as a separate business, that separate part constituted a trade. And he then says that approach, Mr. Thornhill contends, was mandated by the most recent authority from the House of Lords, Ensign, Tanker, Leasing, etc. Now, before we actually just look at the law in relation to this, just standing back and seeing whether that makes any sense is always actually quite a useful thing to do. Take the example of a car dealer who trades by buying and selling cars. That is his trade, it's his business, he does so with a view to making profit and on a commercial basis. That is unquestionably a trading business. Suppose then that the banker comes along and buys a nice car and sells it a few years later. It could be said that he's assuming part of the trade, but is definitely not trading. Or suppose a small importer of goods from the United States, who also buys US dollars occasionally to hedge against currency fluctuations. That would be part of his trade as an importer, but a plumber, who independently from his activities as a plumber, bought or sold dollars occasionally in exactly the same way on his own, would not be a trader, but an investor. In other words, the idea that you can say that because one entity, Warner Brothers, is carrying on the business of, the trade of distributing films and gets rid of a part of that, it necessarily follows that in the hands of that other person, it will necessarily be a trade, does not sound to be correct.
But isn't the judge making a different point here? He's making the point, isn't he, that Mr. Thornhill went on to consider whether somebody carrying on that part of the trade which the LLP was going to carry on, whether people carried out that part of the trade as part of a effectively a commercial business. And that's what he's dealing with. at this point. So he's moved on from Warner Brothers. He concluded because there were others in the film world who carried on the part which was passed to the LLP as a separate business, that separate part constituted a trade. So it's not analogous with your example of the plumber.
Well,
It's looking at the position of somebody who does carry on the relevant part of that business as a trade, and asking the question, and then asking the question, if that's what the LLP is going to do, and it's not a one-off, is it? You know, it's not as if they're only going to do it for 5 minutes. Your plumber example. Speaking for myself, I can't see what's wrong with that analysis, but
Particularly where the trade is not just selling cars or investing, it's a trade of acquiring by way of license and then exploiting the distribution rights to films in the territory, which is what otherwise Warner Brothers or the sub-distributors would have done.
Well,
and that's the comparison that's being made.
well, the reasoning, if one goes back to the opinions and sees how it's a summary, is that because you've taken part of the trade and because Warner Brothers were trading, that leads to the conclusion that it's trading. And I at the moment, I'm simply on that being false. But
Right. Or oversimplistic.
Sorry?
Oversimplistic, perhaps. Or just plain false, you say? The whole logic is false?
The whole logic is false. I mean, my essential point, picking up on my Lady Justice Simler's point, you have to look at what it is that's being done by the LLP. You've got to look at the badges of trade, you've got to look at Livingston.
Well, badges of trade are all very well where you've got buying and selling cars, but where you've got acquiring licenses and then exploiting the distribution rights. Do badges of trade really come into it? Which are the badges of trade that you say should be looked at in this context? Because I find it quite difficult in the context of exploiting licenses and film rights.
My lady, I will get directly to badges of trade. There are 9 of them, and we say that if you look at 6 of them, there are serious question marks being raised against them. But for present purposes, I'm agreeing with your ladyship that what you have to focus upon is the issue about whether or not the LLP is trading.
Yeah.
If it is, fine. I mean, subject to the additional element of on a commercial basis, but if it fulfills those tests, fine. But what you can't say is simply because you've taken part of the business from someone who is trading, Warner Brothers, ipso facto, that means you are trading. And I need to pick up my Lord the Chancellor's point as well, which is, it does matter as to whether or not this is being done on a commercial basis. One of the issues.
well, that goes without saying, but that's the second part of the. I mean, the judge seems to me in 177 is recognising that there are 2 stages. The first stage is were they trade? Is it a trade at all? And the second stage is it being carried on a commercial basis, carried on commercially? Because he deals with that by saying, well, he asks himself the question: has it been denatured?
Well, can I just, before we get to 177, you see the judge rehearsing at 176 what we'd been said about how you approach the matter. The claimants contend that those authorities, and we will have to look at a couple of them, established the approach was a multifactorial one, which required an analysis of all aspects of the specific transactions entered in by the LLP and the application of that transaction of various tests. Then badges of trade, which I put on the too difficult pile for a minute, but will, I promise, come back to. Whether there was a genuine commercial purpose, whether there was a difference between the shape and character of the alleged trade and as carried out in taking account of all matters, whether the transaction is speculative and whether there's a genuine intention to make a profit. I'll refer to this as ground up. So he's saying that's what we said. And we say, just for the avoidance of any doubt, 176 is exactly the right approach. And as I say, I promise, come back to badges of trade. I don't resile from that. But the essence of it, this is a multifactorial matter where you need to look at everything and come to these decisions. And that's what the statute requires, it's what the cases show. And then what the judge says is the essence of the approach adopted by Mr. Thornhill, so he's discussing what he did, was to start with the uncontroversial proposition the activity carried on by Warner Brothers was a trading activity. He then considered whether the fact that the LLP was carrying on only a part of the trade meant that the LLP was not itself trading. He concluded that because there were others in the film world which carried on the part which was past the LLP as a separate business, that separate part constituted a trade. While the terms on which the LLP could negative the conclusion, that would only be the basis if the way the trade was carried out for tax revenue was substantially different from the way it would be carried on commercially. It was denatured. That approach, Mr. Thornhill contended, was mandated by the most recent authority from the House of Lords. So he's saying that you've got this separate thing called the Ensign approach, which is to be in contradistinction to what is at 176. Now, my submission is what is meant by that what the judge is doing in that context is accepting Mr. Thornhill's view that you could take part of a trade or not. The only possible other one is that he's assuming what you have to prove in terms of there are others in the film world who carried on the part which passed it as a separate business, that separate part constituted a trade. Well, that begs the question. Who, on what terms? And so
There were sub-distributors, weren't there?
But
So aren't they doing...
who on what terms?
But does it matter what the terms are? Because the terms will determine how risky, how much profit, all of those things. The question at this point is, are they trading?
Yes, but even trading has, as it were, a commercial element to it. We're not yet at the commercial separate element, so one needs to then look and consider who these comparators are, how they compare with the business of the LLP and so on. Now, what the judge then does, after he's and you can see the judge summarising what he thinks he's done at 220, which is in accordance with what I've just said on page 118. In particular, I consider that a reasonably competent tax QC could have concluded that a different approach to that mandated by the cases on which the claimants rely was possible, where the transaction in question involved the taxpayer assuming part of what was undoubtedly a trading activity correlated by another. Such a tax QC could have construed both Lord Templeman and Mr. Justice Millett in the passage from Ensign Tankers as essentially adopting that approach, might reasonably conclude that the prices right on the claimants in which the ground-up approach was adopted were distinguishable. So
he says the authorities working backwards relied upon by your clients, the authorities coming from 2002 to 2004, are essentially not the relevant ones, and a reasonably barrister could so have concluded.
yes, Milady, in fairness to the judge, what he's actually concluded is that a reasonably competent tax silk could have thought that there was a different approach. He's certainly not saying that the ground-up approach was one which no reasonably taxed silk could have taken. And just to make the completely obvious point, that becomes quite relevant when one gets to no doubt and so forth. But that's what he's saying. But then you've actually just got to read the passages which are actually set out. Now, I don't want to do that, but he sets them out, and
This
my
is in
submission.
Ensign.
Sorry,
This is in Ensign.
this is Ensign. He sets out in Ensign the passages which he says permits that, and the passages, just so that we identify them, are in Mr. Justice Millett's first instance judgment at 191, and I'm sure you're all intimately familiar with Ensign. But what happened at first instance was that Mr. Justice Millett allowed tax relief of £22 odd million, which included in relief of money which had only been borrowed. The Court of Appeal overturned him completely And the House of Lords came back and said, well, you're not having 22 million, but you can have 3.75, which was in relation to the 25%, which was actually provided by the taxpayer. So the relevance of Mr. Justice Millett is that he gets it half right. The Court of Appeal, according to the House of Lords, get it wrong, and then Lord Templeman comes back. But for present purposes, what the judge is relying on is the statement by Mr. Justice Millett, which start at 191 and go through continuing to identify the various passages in Mr. Justice Millett's decision, and he stops with Mr. Justice Millett at page 100 or paragraph 198. Then he refers to Lord Templeman at page 201, and then he goes back to Mr. Justice Millett at 203, deals with Barclays Mercantile, deals with some other matters, but his conclusion at 220 is such a tax QC could have construed both Lord Temple and Mr. Justice Millett as essentially adopting that approach and might reasonably have concluded that the cases decided by the claimants in which the ground-up approach were adopted were distinguishable. Now, our submission is very straightforward. There is nothing in what Mr. Justice Millett said or what the House of Lords says which justifies that conclusion. How you go from the cases telling you that it's multifactorial and so forth to you don't need to look at that because of what Millett and the House of Lords have said is, we submit, simply not explained and is wrong. And that key error can actually be seen in our submission from looking at one small part of Mr. Justice Millett's decision at first instance in Ensign Tankers. You got Ensign Tankers, Bundle 1, tab 11.
Mr. Thornhill's position was to this effect, that was it not? It was his view that the House of Lords and Ensign Tankers had established that distributing a film or producing it was inherently a trading activity, and he would reach the same conclusion today, albeit by the multifactorial route.
That is what he said. But just going back and just looking at whether this actually makes sense, Mr. Justice Millett's decision is at tab 11 of Bundle 1, and if you would go through, please, to the very last page of that judgment, you'll see that he's dealing with a submission which starts at the bottom of 280 by the Crown. The Crown submitted that not merely the creation of the partnerships, all the arrangements entered into them should be disregarded as mere paper transactions which had no impact on the making or distribution of the films. They were submitted steps which had no commercial purpose apart from the avoidance of liability to tax. In my judgment, the submission cannot succeed as an independent point since it's logically impossible at one and the same time to find the partnerships were trading the transactions which they had entered had no commercial purpose. But the transaction provides a useful cross-check on the conclusion that the partnerships were trading. In my submission, in my judgment, the submission is hopeless. It's impossible, supposing it were permissible, to discard the part played by Victory Partnership, for example, and to give effect to the remaining arrangements to make the film without leaving a £3.25 million hole in the financing arrangements. Of course, sorry, I've now lost my place. Of course, if Victory Partnership had not put up this sum, Chemical Bank would have advanced it. The Victory Partnership is, etc. And then going down to just above C after he's gone through the steps. Each step leads to another. No part can be ignored until the whole is brought. Yes, the whole cannot be ignored without leaving the financial arrangements incomplete or reverting to those for which its own commercial purpose LPI abandoned in the arrangements with Victory Partnership.
Yeah.
Now, my lords, the second critical feature is in relation to what's referred to as the Livingston element of the trading test. Now, again,
So are we going to look at what Lord Templeman said, or?
well, my lady, I'm very happy to look at what
Well,
Temple.
It's quoted by the judge.
Yes.
And
Yeah.
presumably you'll make submissions about it, but
Well,
Scott set
I mean,
out
it
to
is-
establish a trade of acquiring and exploiting distribution rights, and what Lord Templeman said is that this Victory Partnership spent money and capital making and exploiting a film, and that was a trading transaction.
that, in my submission, does not establish the proposition which is sought to be used for, that taking part of another transaction of another is ipso facto a trading transaction. There isn't some special rule which occurs in those circumstances. In my submission, no reasonable tax silk could have thought that was to be the position. How could one take from one example in one case the general proposition which is sought to be contended for? I mean, the proposition has to be that as a matter of law, Lord Templeman was laying down a rule that if you take a part of one business and transfer it to another person, that first business trading, then the second one will also be trading. And it's in my submission, just, it doesn't make sense. You've already got this point, which I've already made, that if we look at section 42, which is on the statute book at the moment, Parliament hasn't said when introducing statutory concessions for the film distribution business that this is in relation only to trading, or that film distribution is inherently trading or anything of that nature. It refers to a business or a trade. Now,
But if one goes to Lord Templeman's speech, which the judge cites at 201 of the judgment, says, in the present case, a trading transaction can plainly be identified. Victory Partnership expended capital in the making and exploitation of a film. That was a trading transaction which was not a sham and could have resulted in either a profit or a loss. Now, on the back of that, was the judge entitled to conclude that a reasonably competent silk could take the view that the partnerships here, equally expending capital in the making and exploitation of a film in a transaction which was not a sham and could have resulted in either a profit or a loss, was equally.
the answer is, my lady, no, because trading is a factual conclusion. Of course, you could analyse a position and say, well, look, in that particular factual case, the facts were these, the facts were materially the same, in the same conclusion or so forth. But the
Yes.
idea that any tax silk could say that because he said this in relation to this transaction, it follows, as night follows day, that it is trading, is in my submission simply illogical.
So you rely very heavily on the ipso facto, it follows without more
Yes.
That's your objection.
Yes, and
But if it's right that the person who makes and then shows the film is trading, doesn't it follow that the person who gets a license to exploit the film once it's made is also trading?
No,
Unless it's a sham or they're not doing it
Or
in a
dilettante
commercial
or
way, or if they're a dilettante and
but all of sorry.
the whole, the point is, it's a trading transaction. It may be negatived by a totally tax avoidance motivation, or it may be recharacterized as a sale and leaseback, or it may be that it's not something that could ever have resulted in a profit. But isn't it a trading transaction in the same way as it was a trading transaction when the person who made the film exploited it?
Milady, my answer to that is no, not necessarily, because even within your ladyship's posing of the question, there are a whole series of different parts. Take only one part. One has to look at the terms upon which the distribution is taking place. There is
You've
no
accepted that they would result in a profit, haven't you now?
trading with a view to profit,
Yes.
but that doesn't get rid of the need for speculate. Sorry.
But what is it that undermines the parallel between the person who makes the film and exploits it and the person who takes a license from that person and exploits it?
Because you are not taking you're not the elements which Warner Brothers are taking account of in relation to their distribution are not mirrored in the terms upon which the LLP is carrying on the transaction. And your lady says, well, what about terms of the profit? It's still got to be, for example, a speculation in the nature of a venture. I mean, you've actually got to say, if you actually have taken it so that you've got effectively a guaranteed profit with no upside and no material downside, assuming risks, that looks awfully like an investment. It does not look like a trade, whereas
The
it may...
call option altered the whole of the way in which the waterfall would come out, didn't it?
Yes, my lady. At the moment, I'm... Well, sorry, can I sort
That's
of...
a slightly different point.
Yes. Can I just back up?
Yeah.
The proposition
Yeah.
that your ladyship was putting to me is that because in the hands of Warner Brothers, the business of distributing a film will be a trade, and the license is then given to the partnership, what is there, you're saying rhetorically, that could stop it being a trade? There are two parts to that question. The first is the general, and the second is the specific. In relation to the general, it involves looking at the terms upon which the transaction takes place, contemplating whether or not in the hands of the LLP this is or is not trading, or more accurately, the likelihood that it will be accepted as trading, and then obviously separately, whether or not it's doing so on a commercial basis. So that's the generic answer, and simply because you've got part of the business being passed over to someone else doesn't, as it were, prove it. So far as the generality, so far as the specifics are concerned, could we, for these purposes, please, just consider the elements of the trading test? Now, take as it were as read that trading is multifactorial. There is no one element which scuppered other. As part of the trading test, one element is the so-called Livingston element of the trading test. Now, not for you, my lady, but just in relation to anyone else. Livingston comes from an entertaining case back in the 1920s when a ship repairer, a blacksmith, and a fish salesman employee who had not previously been connected with each other bought a cargo steamer to convert it. And they did so, and they sold it at a profit. And they made £963 between them. And in making that £963, they paid the ship repairer for his wages. In other words, it was after it had been done. And if one looks at Livingston, Bundle 1, Tab 3, page 57, Authorities Bundle 1, Tab 3, page 57, you'll see that at the bottom of page 61, the Lord President, in the passage which is highlighted, it says, "I think the profits of an isolated venture, such as that in which the respondents engaged, may be taxable under Schedule D, provided that the venture is in the nature of trade. I say maybe because in my view regard must be had to the character and circumstances of the particular venture. If the venture one consisting in an isolated purchase of some article against an expected rise in price and a subsequent sale, it might be impossible to say the venture was in the nature of trade, because the only trade in the nature which could possibly would be the trade of a dealer in such articles, and a single transaction falls as far short of constituting a dealer's trade as the appearance of a single swallow does of making a summer. The trade of a dealer necessarily consists of a course of dealing, either actually engaged in, or at any rate contemplated and intended to continue. But this principle is difficult to apply to ventures of a more complex character, such as that which the present case is concerned. I think the test which must be used to determine whether a venture such as we are now considering is or is not in the nature of trade is whether the operations involved in it are of the same kind, carried on the same way as those which are characteristic of ordinary trading in the line of business in which the venture was made. If they are, I don't see why the venture should not be regarded as in the nature of trade, merely because it was a single venture which took only 3 months to complete." Now, what is there being said, first of all, is the emphasis, obviously, that you have to look at the facts. Secondly, by strong implication, the fact that you only do something once is a strong indication against it being the nature of a trade, because normally trade is repetitive. But nonetheless, what you need to do is to look at whether the operations involved are the same kind, carried on the same way, characteristic of ordinary trading. And simply because you have got Warner Brothers doing something does not tell you anything about whether the trading carried on by the putative trading carried on by the LLP fulfills this Livingston test. Now, in this context, and do you mind if I just make this point finishing off on this? At the judgment, paragraphs 224 and 304, the judge deals with the Livingston test. So far as the Livingston test is concerned, I consider that the reasonably competent tax QC could have concluded that the fact that the separate activity carried on by the taxpayer was carried on for a purpose that was at least in part commercial, so not solely for fiscal purposes, would be supported by the fact that such separate activity was itself carried on in the real commercial world. While this involved determining whether it was carried on the commercial way in a similar way, it was reasonable to take the view that this required focus on the activity being undertaken, as opposed to, for example, the terms on which profits were divided between those involved in the activity. The latter would be relevant to the question whether the trade was being carried on commercially with a view to profit, but a reasonably competent tax QC might have concluded that difference in the level of upside potential or downside risk were not relevant to the question of whether the part of the trade being assumed by the LLP was carried on in the same way in the commercial world. Well, that's very, very difficult indeed. The purpose of trading is to make a profit. When we're looking at this element, one's saying, are you carrying on business in the same way? And what the judge is saying, well, it doesn't matter. if actually the terms upon which you're carrying on business are completely different in terms of profit. Profit being, I might add, the whole purpose of the venture in the first place. And this shows in my submission that the judge approached the Livingston element test incorrectly. To similar effect is what he says at paragraph 304 on page 134. Coming back to the Livingston test, additionally, they contend the actual comparators with which Mr. Thornhill was presented didn't involve the trade being carried on a similar way because of the lower level of guarantees. Mr. Thornhill's response to that was the level of guaranteed income available was not relevant to whether the operations undertaken by the LLPs were the same kind and being carried on the same way elsewhere in the commercial world. As I've noted above, a reasonably competent tax QC could have taken the view that differing levels of guarantee was a factor. It was relevant to the extent of speculation, the likely level of profit and loss, but didn't impact on the way in which the trade was carried out. Well, and I say that when one stands back from this and looks at this from the point of actually what you're trying to see, whether this is trading, saying, well, you're going to look at whether trades are coming on the same way, but you're going to ignore the commercial terms, which is the effect of what the judge is saying, makes absolutely no sense whatsoever. Now, my lady, I am going to answer the other specific requests in relation to, as it were, I can rephrase your question, what's the matter with the trading test, but I will, if you don't mind, do so tomorrow morning. Can I tell you that
before you do that, can we just, I think the court would find it very helpful if you were to summarise, if appropriate, on a couple of sheets of paper, no more than a couple of sheets of paper, the point that you were really making about duty, the duty of care point earlier on, between about sort of, I don't know, 2:20 and 3:15, because I think we felt rather confused, and I think it might help you and your client if you were to focus on the points you were trying to make.
I will
put them down
I
on
will
a piece of paper.
certainly try and, well, I'll look at the transcript and see what on earth I was talking about between those times and try and make sense of it.
Well, I only say that 2:20 because you started off this afternoon talking about the application documents and the subscription agreement. You don't need anything about that. It's really when you moved on to duty.
Very, very good, my lord. I will certainly do that. Well, can I just tell you, my learned friend and I have had a discussion. We've agreed that time will be split equally between us. For present purposes, I've told him that I am intending to finish by the mid-morning break tomorrow. If I go a little bit past that, it will have consequences for how long I've got in terms of the reply at the end, but just so you know where we are.
Okay, thank you very much.
All right.
10:30.